Good afternoon and welcome to our program on judicial nominations, and we are honored today to start out with an address by Senator Arlen Specter. The senator is, certainly, as they say, needs no introduction, and I will give him therefore only a very brief one. He's been a senator since 1980. The longest-serving senator, I believe, in Pennsylvania history. I've heard his name since the 1960s when I was growing up, listen to KYW radio on occasion, back when you were district attorney and you were in the news all the time, almost as much as you are today. He is someone I suspect people from all sides would say, if you're in a good, tough, hard-nosed political battle, he is someone you want on your side. He has had quite a record over the years on Capitol Hill, and he's really been extremely effective in recent years. Last 2 years, he's been chair of the Judiciary Committee. He ended up chairing the first two Supreme Court nominations we've had in over 10 years. I think widely recognized as having been a very fair chairman and having done a very good job on the process. He has, as I say, just been a major force in the Senate in his time there. I think one quote I saw about him said that he had more power and influence than many sovereign countries. And perhaps that's a good place to ask you to give a welcome to our speaker today, Senator Arlen Specter.
Thank you very much for putting me into the sovereign nation category. The Philadelphia Inquirer did write that line, but it's totally taken out of context by that very generous introduction. They had a lot of other things to say about me, not quite so complimentary. The Judiciary Committee is a real battleground. And when you have on the left actually seated there Kennedy and Biden and Schumer and Durbin and Leahy, Feingold, and on the correct side, not the right side, but the correct side, you have Coburn and Cornyn and Grassley and Sessions and Orrin. It's quite a battleground, and to be in the center, and we steered our way clear on the Supreme Court nominations, as you know, and there's a real overhang from some second thoughts about not filibustering Justice Alito. They tried very hard to find some traction to do that. They're thinking about 1991 when they didn't filibuster Justice Thomas, and they're still talking about that from time to time, a 52-48 vote. And they were really struggling for some traction. And you may recall when Senator Kennedy interrupted the proceedings and moved to go into executive session to get the Alito records from the concerned alumni of Princeton. And I said to him, well, if you really were serious about it, why didn't you mention it when we were in the hall instead of springing it in the middle of this proceeding? Or why didn't you mention it in the Senate gym? Of course, I had to point out that Senator Kennedy hadn't been in the Senate gym since the Johnson administration. That was the Andrew Johnson administration. But on a very serious note, it is a real battleground. and we're battling it day by day. The statistics are that in the final 2 years of the Clinton administration, there were 15 circuit judges confirmed and 57 district court judges. And so far in the 110th Congress, only 6 nominees for the circuit by President Bush have been confirmed, 34 district judges. So we've got to get 9 more this year if we're to meet the Clinton standard, and that's what we're pushing for. That's the standard. During 8 years of Clinton, he had 65 circuit judges confirmed, 305 district judges, and President Bush has 57 circuit judges and 237 district judges. There are still some battle scars when we were successful in confirming Bill Pryor and Janice Rogers Brown and Priscilla Owen coming out of the filibusters early in my chairmanship. And we're trying to battle through. We have 14 circuit vacancies and 10 nominations pending. And some of the problems we're trying to work through. The president has not followed Senator Warner's recommendations, and you can't get a nomination processed if you don't honor the views of the Republican senator in the district. And there's no doubt that the Democrats are waiting for next year. They think they have a great opportunity. Well, it might not be as great as they think. Who knows what's going to happen in this topsy-turvy presidential race? If, depending on how it works out, it may not be a year for the Democrats, which they're counting on very heavily. And the New Jersey senators are pretty blunt, waiting for next year. So are the Rhode Island senators. And in Michigan, they want to have a commission appointed. They don't like the constitutional provision that gives the authority to the president to nominate federal judges. Well, we're not going to change the Constitution for Michigan. But on the other hand, there's a stalemate. And we've got a great candidate in Peter Keesler for the 10th D.C. Circuit. It's pretty hard to find a better candidate than Peter Keesler. Of course, that's part of his problem. He's too good. If he gets the D.C. Circuit, they're worried he's going to be a nominee for the Supreme Court. So the checkers game is played way down the line. And that issue is complicated by the fact that we Republicans took or some of the Republicans on the Judiciary Committee took the position that we ought not to fill the vacant seats on the District of Columbia Circuit Court. And one of those has now gone to the Ninth Circuit. The chessboard has multi-layers. It's complicated all by itself. And there's a lot of disagreements trying to get a district court judge in Louisiana. Let me tell you, if there's any place that needs to fill a vacancy in the district court, it's Louisiana, with their pileup and litigation on the hurricane. And trying to map some strategy with Senator Vitter. And relationship between the two Louisiana senators are not exactly copacetic. And I won't tell you any more. I know all of this is off the record. And nobody will repeat anything I said, and there's no film in that camera, so I feel very much at liberty to share all the inside confidences with you. Sat down with Senator Elizabeth Dole yesterday about the Fourth Circuit. She's got a candidate who's been waiting practically forever. I sent Senator Leahy a well-constructed, single-spaced, 2-page letter. I usually write very short letters because nobody reads long letters. And a couple of days later, I got a single-spaced 4-page letter. And I think it's better not to publish the letters if we want to maintain a conversational dialogue between Senator Leahy and myself. And we're working very hard to smooth the bumps, and I'm concentrating right now on Robert Conrad and Katharina Hayes and Steve Matthews and Gene Prater, all of whom are close to being ripe. Gene Prater, not quite, but the other three are on the list, and trying to move it a step at a time. And we had a big victory with Judge Leslie Southwick. Big victory. Judge should have been Wallace, who's in the audience here today. Had a real battle there. And we sat down and talked at the outset, and I told him what the trials and tribulations were going to be. He said he wanted to go, knowing the difficulties. Had a long conversation. And then I spent 30 minutes on direct examination as chairman. Went over under the trial lawyer's practice of going into all the problems so that they wouldn't be disclosed somewhere later. No reason why he shouldn't have been Judge Wallace. No reason at all. But confirming a nominee with his credentials was nearly impossible in the Fifth Circuit. And when Leslie Southwick came up with the kind of a record he had, and two arguments on concurring opinions, and volunteering to go to Iraq, you couldn't find a better state appellate court judge, couldn't find a better poster child for confirmation to the circuit and Fifth Circuit. And thanks to help from the Federalist Society and the various organizations, we had a whole series of news conferences, really pressing very hard. And finally we got a little give, and Senator Feinstein couldn't resist acknowledging how good Leslie Southwick was, and we got him confirmed. And there are some objections now pending as to some of the others. Gene Prater, I wrote the statistics down before coming over, has written 278 opinions, and there have been 103 appeals, and she's had 2 reversals and 1 vacating of one of her judgments. Well, that's a pretty good record for a district court judge, and I've known her for years as a practicing member of the Philadelphia Bar, and she's really very well qualified, but there's opposition, so we will see. On a collateral issue, which has some bearing on what we're talking about, the judicial pay bill is on the Senate calendar for today. And the judges ought to be we ought to have better compensation. And one of the interesting parts of my job is to be lobbied by Supreme Court justices. Pretty interesting when you have an argument about whether the justice is going to come to my office. I don't have chambers. I don't know how judges have chambers. I'd like to have it explained to me someday where I only have an office. In fact, I have a hideaway office. It's even denigrated further than an office. But at any rate, we're having a lot of conversations. And I brought up the subject of televising the Supreme Court. After listening for about an hour, I figure I'm entitled to 3 or 4 minutes of my own. And I feel very strongly about televising the Supreme Court because I think people ought to understand what the Supreme Court does. I think people ought to understand how our system has evolved to give them the final say on all of the cutting issues. And we talk a lot about wanting judges to interpret the law, interpret the Constitution, not to make social policy, but that is a concept not understood. President Bush did a good job. It was a key part of his campaign in 2004. And perhaps the real legacy for President Bush is going to be Chief Justice Roberts and Justice Alito. And trying very, very hard to get that done. I think if we were successful in really informing the American people about what happens in the court system and how Congress punts so many of the issues to the court, ought to decide them ourselves, legislators, but we don't want to take the rap for a lot of very hard votes, end up sending them across the street to the Supreme Court. I regret that I can't stay for the panel. We have the stimulus package on the floor this afternoon, trying to find our way through that morass. And we have FISA waiting in the wings, trying to give the National Intelligence Service an extension on the Foreign Intelligence Surveillance Act on the important information they're getting from their electronic surveillance. But I'm glad to respond to some questions. I always add promptly after saying I'm glad to respond to questions to say that I'm equally glad not to respond to questions. But it's up to you. Yes?
Senator, do you regret the, for lack of a better title, the Gang of 14 arrangement that was achieved the previous session, previous Congress?
No, I don't, because we got Bill Pryor and Janice Rogers Brown and Priscilla Owens. And we'd still be arguing about it if we hadn't found some way to cut through the morass. And if we hadn't gotten that done, we wouldn't have gotten Chief Justice Roberts and wouldn't have gotten Justice Alito. The disagreements get very, very intense, and I don't want to call them enmities or categorize them beyond the scope. But I was not. I was chairman, and I attended the meetings, but I thought I should not be part of the Gang of 14. I had too many responsibilities to preside, and not to vote or not to have too heavy a hand. But you had the majority leader, Bill Frith, coming to the meetings. And you had the minority leader, Harry Reid, coming to the meetings. And they'd pretty much abdicated what they were doing as leaders. They were going to somebody else's hands. And I think if you had taken a private poll among the 100 senators, the Democrats wouldn't have filibustered, and there wasn't unanimous support for the constitutional or nuclear option. We're really groping. And we gave up a little. We got a lot more in the deal than we gave up. Judges I just mentioned, Brown and Pryor and Priscilla Owens, and then we got the big guys. So we came out ahead on that deal. Yes? Yeah. Oh, yes, ma'am.
Do you support the judicial pay bill that's currently before the Senate Judiciary Committee?
Well, happily there's so many before the Judiciary Committee, I don't have to take a position.
I'm talking about S 1638.
Bill 1638, I know all the bills up to 1637, but my reading list ended. We're going to hassle it out. I don't really want to say. I want to give them a raise where they won't be coming back too soon. And I also want to eliminate some of the perks. I want a lot of transparency in what the judges do. And I'd like to get it done without spending 2 years on it. So we're talking. Yes.
First and foremost, I agree with your take on the Gang of 14. I think because of that, I know this might not be the crowd to say it in, but I think because of that, we did get the judges that we have. But
I'm glad to have at least one supporter of the Gang of
definitely.
14. I'm not unused to saying things in crowds where they're unpopular. That's part of my pay grade.
Quick question for you. What are some practical steps that you think that you can take? Because there is this logjam in the Senate Judiciary Committee. I know that things have been tossed around as whether a 2-hour rule on the Senate floor, denying quorum in committee. I mean, it seems like we are at a point where the clock is running out. What do you think are some practical steps that we can take to kind of shake Patrick Leahy and gang loose?
Well, we've considered about all the options. One option we've considered is not showing up at Judiciary Committee meetings, so the Judiciary Committee can't function. And then you mentioned the 2-hour rule, to object to any committee meeting which runs longer than 2 hours after the Senate goes into session, which would pretty well tie up the Senate. Then you start adjourning the Senate midday so committee meetings can go on. They had to do that. And then we've considered tying up the entire Senate. We can do that too. Any one of us can tie up the entire Senate. Call for a reading of the journal every day. There are a lot of easy ways to tie up the Senate. And we're at a period where we're trying to have some breakthrough and conciliation, trying to work with the president on the stimulus package, and holding off on the contempt citations, for example. The House was about to take those up, and not wanting to put Harriet Miers in leg irons while we're trying to get the stimulus package through. And they're all on the table. And meanwhile, a lot of us are talking, trying to work through these issues, trying to get people confirmed. If we have to take them one at a time, like Southwick, we can do that too. We can do that too, and we're prepared to do it. Everybody got an easy question? Listen, let me thank you for all you do for the Federalist Society. I spoke to the Pittsburgh chapter a few weeks ago. I'm talking to the Philadelphia chapter, and I was here for your giant soiree last year. And you practically had a quorum of the Supreme Court here. You had four justices. Pretty impressive showing for a group which has been in existence. You're relative newcomers from the early '80s on the legal political scene, and it's great to see what you're doing. And the scholarship is very, very important. I sometimes joke that we have 70 members of the bar in the United States Senate and 5 lawyers. So strike that from the record. So it's great to come before a group of people who are real scholars. Thank you all for inviting me.
Thank you very much, Senator. This meeting is co-sponsored by our D.C. Lawyers Chapter, and we have a tradition in the D.C. Lawyers Chapter of giving our speakers a copy of the Federalist Papers, and I would like to present that to you.
I'm pleased to tell you this is not my first copy of the Federalist Papers.
we thought that might be the case, but thank you, Senator, very much. Thank you, Senator. Could I ask our panel to come up to the table? One of these we lay down.
Turn it around for him.
That's right, exactly. Exactly, yes, thank you. So we have everyone in the... Yeah. Just very briefly, I want to introduce our moderator for our panel. David Savage has been the longtime Supreme Court correspondent, Supreme Court reporter for the Los Angeles Times, and we are delighted to have him here. And I think without further ado, I will turn it over to you.
Thank you. It's good to be with you. I've had, I wouldn't call it the pleasure of covering a lot of Judiciary Committee debates about judges, and that I go back to the office and we sit around and talk, and I have a few friends who've covered the Israeli-Palestinian, the so-called peace process, and I always think when we talk at lunch, it seems to be the same, rather similar thing, that everybody can point to 10 years back, but they did this to us, and the other side says quite correctly, yes, but they did this to us, and so on. It seems to go on for decades, and if anything, gets ever more bitter. we're going to try to have fun with the topic today, and to the extent that we can. We've got 4 speakers. I'm going to give a brief introduction for each of them, and then we're going to go in sort of order. Each of them are going to say something for 5 or 10 minutes, and then we're going to try to just open it up to questions. Here, I think you probably know a little bit about some of all these. Ed Whalen is the president of the Ethics and Public Policy Center here in Washington. He's a writer and commentator on constitutional law issues in the Supreme Court, and I hope many of you read his bench memos on the National Review online. They're one of the always fun and provocative, and Ed's sort of a take no prisoners type of guy. Sort of tells you what he thinks, and I always find it quite interesting to read. He's served in all 3 branches of government, which I think is quite interesting. He was a law clerk to Clifford Wallace in the Ninth Circuit, for Justice Scalia at the Supreme Court. He was on Capitol Hill. He was a counsel to the Senate Judiciary Committee, and he was also a lawyer in the Office of Legal Counsel to Justice Department in the first Bush term. Next to me right here is Simon Heller. He's now the legal director for the Alliance for Justice, heads its judicial selection process. I've known Simon for a while. He was a lawyer for many years, and some of the abortion-related cases for the ACLU and the Center for Reproductive Rights. You'll probably know the Alliance for Justice. It's sort of a coalition of civil rights, civil liberties groups, unions. It's sort of the vast left-wing conspiracy on this issue of judicial confirmations. It's been fighting for 20 years or so to opposing a lot of Republican judges. So I'm sure you're at least familiar with the organization, although, as I say, Simon is somewhat of a newcomer. Michael Wallace has agreed to be Mike Wallace for this session. Since we have 2 Michaels on the panel, he kindly agreed to be Mike because he is Mike to his friends. He's a longtime lawyer from Mississippi who's done all sorts of commercial litigation, is also the general counsel for the Mississippi Republican Party. I see his name every couple of years as a case comes up from Mississippi involving either electoral districts or some election issue, and Mike's been involved with those for a long number of years. He was in the late 70s a law clerk to then Justice Rehnquist, and he's also worked for Trent Lott both in the House of Representatives and the Senate, and he also has, I think, a more of a personal story than anybody else here, maybe anybody else would want to have, about the perils of the confirmation process, so I'm sure he'll say a little bit about that. And finally, on my right over here is Michael Gerhardt, who's a law professor at the University of North Carolina at Chapel Hill, a fine school where I've spent a few delightful years. Michael is a scholar of many topics, including impeachment and filibusters. 10 years ago this month, I think, was the time most of us learned the name Monica Lewinsky. And you sort of remember how that played out for the next year. And Michael was one of the nation's experts on the impeachment process. So all during the CNN and whatnot, he was sort of both quoted in the press and frequently on TV talking about that subject. He's taught at William and Mary and Duke and Cornell, and as I say, is a real expert on the federal judicial appointments process. So each of the speakers is going to take 5 or 10 minutes. I said I could bring a hook along after 10 minutes, but they've instead said put up a sign that says 2 minutes, so I think I'll try that rather than using the hook. But we're going to try to hold everybody to inside 10 minutes. Ed, why don't you go first?
Thanks, David, for your kind introduction. And thank you to all of you for being here. The current state of the judicial confirmation process can best be understood against the backdrop of events of the last 7 years. I'd like to use my opening remarks to call attention to several respects in which the process has suffered severe degradation during this period. Now, let me emphasize at the outset that my position is not Senate Republicans good, Senate Democrats bad. If I had to encapsulate in a few words, it would instead be Senate Republicans bad, Senate Democrats even worse. But I hope this discussion will enable me to flesh out my criticisms of both sides. Let's begin with filibusters of judicial nominees. Now, let me make clear at the outset that I do not take the position that judicial filibusters are unconstitutional. I think it's clear that each House has plenary authority to set its own rules. Cloture rules are part of that. That said, it has long been an established practice in the Senate not to filibuster judicial nominees. Until the presidency of George W. Bush, there had never been a partisan filibuster against a judicial nominee. Indeed, the only previous instance of a filibuster of a judicial nominee occurred in 1968, when a broadly bipartisan filibuster, with Democrats providing more than 65% of the votes needed to sustain the filibuster, prevented a final floor vote on President Johnson's efforts to elevate Abe Fortas to Chief Justice. Now, during the Clinton administration, there were a grand total of 4 votes on cloture, on proceeding to a final vote on confirmation on judicial nominations. All 4 were supported by Republican leadership, and none received more than 14 negative votes from Republican senators. But in 2003 and 2004, when after Democrats lost the narrow majority they had in the Senate, they unleashed a filibuster against President Bush's appellate court nominees and succeeded in defeating some 20 cloture petitions on 10 different nominees, 5 of whom were never ultimately confirmed. Then, in January 2006, from the ski slopes of Davos, Switzerland, John Kerry launched a partisan filibuster against the Supreme Court nomination of Sam Alito. That effort failed, but it did garner 25 Democratic votes, including the votes of Hillary Clinton, Barack Obama, and 7 of the 8 Democratic members of the Senate Judiciary Committee. Now, when they were in the minority, Democrats defended their use of the filibuster in violation of Senate practices as a critical tool in keeping the majority in check. But lo and behold, once they had the majority, in October 2007, Democrats took their already unprecedented use of the filibuster to a new extreme as they pursued it for the first time as a majority party against the nomination of Leslie Southwick. 38 Democrats voted to filibuster the nomination of Judge Southwick. Second significant development of the last 6-7 years is the expanded blue slip policy that Senator Specter implemented. Now, Senator Specter deserves great credit for the Roberts and Alito hearings and also for his stalwart efforts on behalf of Judge Southwick. That said, I think one real problem in 2005 and 2006 is that Senator Specter adopted, or I guess we should say appeared to have adopted, since the whole blue slip process is murky, an unprecedented, expansive version of the blue slip policy. Now, let me go back a step. This blue slip practice gives senators influence over supposed home state judicial nominations. I say supposed because circuit court judgeships have no particular connection to the state in which the judge sits as opposed to other states in the same circuit. Under the policy that had been adopted by former Chairman Kennedy, Biden, and Hatch, the return of a negative blue slip would be given substantial weight, but a committee hearing and vote on the nomination would proceed. Senator Specter, Chairman Specter, instead made an unreturned or negative blue slip, including from the minority party, a barrier even to a hearing, and thus gave obstructionist Democrats all the leverage they needed. Third development, minor but revealing, returning nominations during intra-session recesses. During intra-session recesses in 2006, intra-session, Democrats took the unprecedented step of returning nominations to the White House, thus requiring that nominations go back through the committee process again. In other words, a nomination can be pending on the floor, ready for a vote. Democrats sent that back to the White House, who then had to go through the weeks of committee delay again. Not once did Senate Republicans ever deny President Clinton the courtesy of holding nominations over during an intra-session recess. Most remarkably, when President Bush did his best to restore the status quo by simply resubmitting the nominations, suddenly the media jumped all over him as though there was something extreme about resubmitting nominations that had been returned in this unprecedented manner. A clear slap in the face, Senator Schumer exclaimed. Fourth, a remarkable number of negative votes against 2 extremely qualified nominees. I may discuss this in more detail later if it comes up. But let's contrast the votes on John Roberts and Sam Alito, 78-22, and it would have been worse for John Roberts if people hadn't been saving their capital for Sam Alito, and then 58-42 on Alito, with the votes in 1993 and 1994 on Ginsburg and Breyer, 96-3 and 87-9. There are some conventional explanations I think are quite faulty that try to just justify this different treatment, and perhaps we can look into those. Fifth, the ABA sunk to a new level. Now, the ABA, in some respects, in lots of cases, performs responsibly. In one instance involving my colleague here, Mike Wallace, the ABA compounded bias, conflict of interest, manifest incompetence, a stacked committee, violation of its own procedures, and cheap gamesmanship with what I have documented as flat-out perjury by the ABA committee chairwoman in testifying before the Senate Judiciary Committee. Sixth, inordinate influence of outside groups on Democrats. Two quick examples. 2002, Democratic committee staffers indulged the request by the president of the NAACP Legal Defense Fund that a pending Sixth Circuit nomination be stalled in order to effect ongoing proceedings in the University of Michigan racial preferences case. Also, the outside groups pressured Democrats to oppose the nomination of Miguel Estrada precisely because he is Hispanic. And in 2007, on Judge Southwick, everyone thought that Judge Southwick was a consensus nominee, well-qualified rating unanimously from the ABA. Committee Democrats had already unanimously approved him to district court spot. Right on the eve of the hearing, even when Majority Leader Reid and Chairman Leahy had assured the Republicans that Judge Southwick would be expeditiously confirmed, suddenly the left launched a scurrilous attack, and lo and behold, the Democratic puppets got in line. Fortunately, in a commendable act of decency, Senator Dianne Feinstein broke ranks, but I think it's a very telling episode. Final characteristic that I'll mention here, I would summarize as shameless mendacity on the part, particularly of someone who's in a position where he really has to do better, though I think he may be incapable of it. That's Chairman Pat Leahy. I don't have time to document that here. I've done so on my blog. I'll do so again. But you cannot trust what this man says. On Southwick, Senator Specter corrected him time after time after time. It's just blatant misrepresentations of cases. To the very end, Senator Leahy kept repeating them. So I think I'll leave it right there. Give us some extra time. And thank you very much.
Simon, next, you've got a few minutes to reply to that, what sounds like an indictment. If you want to stand up here and use the microphone, feel free to.
I'm closer to it, so maybe I will. And I don't know, I didn't think of it as an indictment. I just thought of it as mostly wrong. But my apologies. But, I think all of us are in agreement probably that the courts, the federal court system, is important to each of us in many aspects of our lives. The courts have a role in determining whether the air we breathe is clean, whether the water we drink is pure, whether we can be discriminated against in the workplace, whether our vote will count when we go to cast our ballot, whether women will have the same opportunities as men. The real tragedy of the last 7 years is that President Bush has used his authority to nominate judges to further polarize the judiciary and indeed to polarize the judicial nomination process itself. As we move now we're in an election year, obviously, as Senator Specter alluded to, the stakes are extremely high, both for many of you here who are in the Federalist Society and want to see the courts move in one direction, and those of us from the progressive movement who hope to see the courts move in the right direction. Again, no offense intended. Part of what has happened, I think, is that we have nominees like Leslie Southwick, who was confirmed to the Fifth Circuit just a few months ago, who, just to give an example of why he was opposed by many progressive organizations, he was unable to give a single example of a case he had decided in which he sided against a corporation and in favor of an ordinary person. He was unable to give an example of it in all his hundreds of cases in Mississippi. Now, maybe that's just the way those cases should have been decided. But the American people have a right to weigh in on judicial nominations and the course of the judiciary. They have a right to expect that judges will respect precedent, will act to advance their individual rights instead of curtail them, and so on. I can keep going, but I won't. Now, obviously, people on the opposing side can say, well, we have a right to curtail individual rights through the court system. I was going to talk a little bit about numbers and statistics. The problem with statistics is that they can always be, this is what, I don't know what the saying is about statistics, but they can always be used in different ways by different people to make the same, to make very different points. So, for example, the vacancy rate right now among Court of Appeals judges is among the lowest it's ever been. There are 14, I think, vacancies in the federal courts of appeals. President Bush has nominations for 10 of those positions pending. Of those 10, at least 6 were made without consultation with home state senators. Now, it's true that the U.S. Code does not assign circuit judgeships to particular states. Nevertheless, there's an extremely long tradition that's been respected by the Senate for many years that the seats of a given circuit should be allocated among judges from the states that comprise that circuit. And so, for example, and I think Senator Specter touched on this as well, President Bush ignored the bipartisan advice of Senators Warner and Webb from Virginia in naming someone to the Fourth Circuit, despite a very lengthy process that those two senators had undertaken to come up with a list of actually very conservative jurists, people on the Virginia Supreme Court, for example, who they believed would be confirmed. He chose someone not on that list. In fact, there are a lot of news reports that Senator Specter himself wanted someone nominated to the Third Circuit, a woman named Carolyn Short, but the Bush administration would not nominate her because her husband is a Democrat. So the role of this president has sought to curtail the role of the Senate in the nominations process. It's no surprise then that the Senate responds in various ways, most of them, I think, not as effective as they could be, but has responded by trying to assert some sort of authority. And this is, of course, part of a bigger pattern that I'm sure you're all aware of President Bush's attempt to expand executive power at the expense of the powers of the other branches of government. So I just want to mention a couple of other things. It's remarkable that we can listen to Senator Specter talk about Roberts and Alito as being two of the great successes, when I think one of the things that came out of their hearings was that they misled the American people and Congress. They told them that they would respect precedent, yet within their first year they overturned numerous precedents, including statutory interpretation that has nothing to do with constitutional interpretation. For example, in the paycheck case involving Lilly Ledbetter, ignored precedent immediately and, in a sense, frivolously, and to the detriment of ordinary Americans. I'll add that I think it's extremely important for the nomination process to work in the future that the Senate and the American people should know what judicial nominees believe about the law. They need to know, does this person support equality for Americans? Does this person support rights that have been recognized for 30 or 50 or 100 years? Refusal to answer those sorts of questions cannot continue. If it does, what happens is the president knows the answer to those questions, but none of us do. And that's bad whether you're a conservative or liberal. We need to be able to understand what the views are of judicial nominees before they announce those views to the detriment of millions of Americans once they're on the bench. Thank you.
I know I can be heard, but I think there are corners in the room that can't see, so go ahead and stand up. They did tell me they'd like me to talk about what it's like to be to go through the confirmation process, but I'm not sure I'm the best witness. Asking a failed judicial nominee why he didn't get confirmed is like asking a patient why the operation failed. We know much less about it than anybody else involved. Senator Specter probably could have told you why if there really wasn't any film in that camera, but I guess we'll all have to wait till know. What I can tell you is what it felt like under the knife. And I can give you an idea of how future patients might be made a little more comfortable than the process we're going through right now. I've been through confirmation 3 times. I was nominated. I went through 2 confirmation hearings to go to the Legal Services Board back in the Reagan administration, and I was confirmed. So I've seen it from both sides. So maybe my opinion may count a little bit. And my opinion is that the confirmation process ought to be tough. I agree with Mr. Heller to that extent. It is an important job. The Senate does have a duty to cut open the nominees and find out what they're like before you put them on the bench. These are lifetime jobs. You shouldn't be surprised. They ought to go through very difficult scrutiny. There has been a suggestion that the horrors of the confirmation process discourage people from accepting judgeships. I don't know whether or not that's true, but if people are discouraged, then I don't feel too badly about it. Agreeing to serve as a judge is service to your country. You either want to serve your country or you don't. And there are millions of people who have served their country and seen things a lot scarier than getting cross-examined by Ted Kennedy. If you can't put up with that, I'm not sure that I want you on the bench. Now, it's true that the process inflicts a lot of unnecessary pain. And continuing the metaphor, when you go in for an operation these days, you get informed consent like mad. I've never met a judicial nominee who felt like he's been fully informed of what's going on. These are people who make it and people who don't make it. So much of this is out of your hands, and you don't know what is being done to you. But it's important. It's an important process, and I agree the Senate ought to dig deep into the nominees. I do have a few thoughts on how the process ought to change. I certainly don't have any advice to the ABA. When Senator Specter was leading me through my testimony a year or so ago, he wanted me to say bad things about the ABA. The best I can tell you is I don't belong to the ABA. I never have. What they do is none of my business. But I certainly didn't disagree with anything Senator Specter had to say about him. I don't have any advice for the Democrats. I'm not a Democrat. I may have a First Amendment right to say what I think, but I don't expect Chairman Leahy to pay any attention to me. But I do have some advice for my fellow Republicans. The day will dawn when there is another Democrat in the White House, and Republicans will have to know how to deal with it. I hope it doesn't happen in my lifetime or my children's lifetime. But it's going to happen, and we ought to be ready for it. And the first thing I would say to Republican senators is meet the nominee and meet him early. The thing that frustrated me the most is that Democrats on the committee, and with one exception, off the committee, absolutely refused to meet with me. I'm being nominated for a major position. They ought to be in a position to have an opinion on it. Absolutely flat out will not meet with me. And it wasn't directed to me. Their position is we don't meet with anybody before the hearings. By that time, I think it's too late to do you any good. I give Senator Biden credit. He let his counsel meet with me, which was very kind. And the one Democratic senator who met with me was Senator Obama, which I appreciated very much. I guess he hadn't been here long enough to learn the rules. But I think you ought to meet with people. It is just flat out wrong to attack people you won't even talk to. And it has been a universal process over the last 7 years, and it's wrong, and it ought to stop. But for the good of the Republicans, you need to do it for self-defense, because failing to meet with the nominee can impair your judgment. You don't know what it is you're being dragged into. Leslie Southwick has been discussed here today, and I think Senator Feinstein did her party a tremendous favor by agreeing to meet with Judge Southwick. Because once she met with Judge Southwick, she understood that no rational human being could have any objection whatsoever to Judge Southwick's confirmation. She understood it was a fight that could not and should not be won. Now, she didn't know at the time that we were going to have a Senate election in Mississippi this year. I promise you, the Democrats running for Senator Lott's seat do not want to spend this year, would not have wanted to spend this year explaining why Leslie Southwick couldn't get confirmed by a Democratic Senate. I think the story is enough in the past now that they may not have to argue with that. But if Leslie was still hanging around because the Democrats wouldn't even talk to him, the Democratic nominees in Mississippi would have no hope whatsoever. The other thing about delay is that it makes you too dependent on the outside groups. They get the fights started, they pick the fights, and you don't get to pick them. And they're well down the road before you even know what the fight's about. And that's one of the things that I find most regrettable about the present situation. When I went home from when I flew home from my confirmation hearings, I was sitting on the row behind Ralph Neese. And I said, Ralph, I feel really bad. I must have put your staff through a huge amount of work to gin up that 38-page report about what was wrong with me. I'm sorry I caused him such a burden. Now, Ralph could have just shown up for the testimony himself and say, I've known Wallace for 25 years. He's against the Section 5 of the Voting Rights Act. Vote no. That's all he'd need to say. But there is a huge organization now. You raise your money, you hire your staff, you issue your press releases, you have to put them to work. And if you don't gin up a 38-page report on people, people think you're not doing your job. By the time the senators actually focus on the nominee, the battle has been joined, and there's nothing left for you to do but choose up sides. So I say to our Republicans, meet the nominees, meet them early, pick your own fights. Don't let somebody else pick them for you. The other item is to be honest about your reasons. If you disagree with the nominee, say so. As Mr. Heller has said, there's a lot of important constitutional issues out there. If you think the nominee is on the wrong side of the constitutional issue, stand up and say so. Senators take an oath to defend the Constitution of the United States. If you think the nominee is a danger to the Constitution, say so and say why. But for God's sake, don't pretend that people are unqualified to be judges. It's not that complicated a job. It's important, but it's not rocket science. Lots of people can do it. We had 3 qualified nominees in Mississippi before we got one confirmed, and if Senator Feinstein hadn't gotten Leslie Southwick confirmed, we could have found more. There's a lot of qualified people out there. Don't pretend people, but that people aren't qualified when they are. One other thing. The Constitution's serious business. If you want to win a war of ideas, you need to discuss ideas. You don't need to tell lies about people. That is going to win short-term points. It is not in the long term going to persuade people of your view of the Constitution. If there's something wrong with the nominee, give him credit for good faith, but say why he's wrong. And in the long term, you may be able to persuade the electorate to agree with you and not with the president. You just can't convert voters by spreading lies. In the long term, it doesn't work. And the final point is don't cry wolf. You do swear to defend the Constitution, but you have to be very careful the fights you pick and where you stand to defend it. There may come a time when it really is necessary to filibuster a nominee to the bench. It's not likely to be at the Court of Appeals level. No matter what they tell you, the courts aren't that important, but the Supreme Court is that important. And there may come a time when either side needs to filibuster a nominee. To that extent, the question about the Gang of 14, they're right. The Gang of 14 got it right. There may be exceptional circumstances. You can argue about when they are, but if you care about the Constitution, you have to concede they exist. But when you're ready to filibuster somebody, when it really counts, nobody's going to believe you it really counts if you spent the last 7 years filibustering Priscilla Owen and Bill Pryor. When you cry wolf too many times and you really need it, nobody is going to believe it. So those are my advice. Those are my thoughts based on my experience and my advice to my friends on the Republican side. And you know, I said Chairman Leahy wouldn't pay any attention. The Republicans probably won't either. But for what it's worth, those are my thoughts. Thank you.
I have a short version and I have a long version. The short version is I agree with everything Mr. Wallace said. So I could sit down, or I could bore you a little bit with the longer version of this, which I think is just an elaboration to some extent of some of the themes that he sounded. But let me go back to a good starting point from the way I look at things. There have been different analogies put forward. Certainly the Arab-Palestinian conflict is a good analogy. I think of a different analogy because I come from academia. I think of faculty meetings. And it has been said, and I can tell you it's true, that the reason faculty fights are so vicious is because the stakes are so small. And I think there is, within the confirmation process, some of the same dynamic. Some of these differences, some of the issues get magnified along the lines I think Mr. Wallace is talking about, but magnified way beyond any reasonable proportions, and that, of course, helps to explain some of the distortions and some of the problems we've seen. What I want to do, if it's all right, is talk about what I think are some different causes of the conflict and how they might be resolved. I'm not going to be casting any blame, at least consciously or expressly. That's not what I see my purpose here to be, and it's certainly not what I'm going to try to do. So a good place for me then to start in trying to sort of identify maybe why do we see the process look the way it does today, or one reason has already been touched on by Mr. Wallace, and that's interest groups. I don't think there's any question at all that interest groups to some extent feel that in order to justify what they do, in order to justify the fundraising that they do, they've got to pick fights. They've got to go out and sort of put together records and pamphlets and so on. And I think this cuts across ideological lines. With all due respect, Simon, if you don't, I just think it's, I'm not questioning people's good faith when they enter into these debates and dialogues. But if you want to know why so much paper gets produced and why, in a sense, sometimes you hear so much sort of sound and fury over particular nominations, that may help explain part of it. Now, of course, I just said sound and fury, which may well signify nothing, because the question then becomes to what extent do the senators hear it? To what extent are they influenced by it? Senators, at least off the record, say that they aren't much influenced by it. And so I don't know whether that's true or not, but one thing it might at least sensitize us to is the need to find out what are the pressure points that get senators particularly interested in nominees and to take positions. What are those pressure points? And that leads me to the second point, which again echoes, I think, what Mr. Wallace said. And again, it cuts across the board. There is a vast need for much greater candor and much greater transparency in the confirmation process. And this, I think, is true for both sides. I think that everyone, or at least I shouldn't say everyone, but I think oftentimes what you see is a lot of dialogue, a lot of positions taken as proxies or perhaps substitutes for other things. People will go after something because they don't want to necessarily have to contend more directly with something else. And I think the process could benefit enormously, not just if people met each other, but if people were much more honest about where they were coming from, what their positions were, and why they were doing what they were doing. That degree of honesty, I think, is hard to find sometimes. I recall that when I was doing some NPR coverage of the Roberts hearings, one comment I made about Chief Justice Roberts was, and I still think this is true, is that as long as you had a Republican president, and as long as you had a Republican president was prepared to nominate a conservative Chief Justice, you were never, ever going to find anybody better qualified than John Roberts. So the question just becomes whether or not you would ever want to vote for such a nominee. That could be the only question. You couldn't possibly make the case that he's unqualified or there's any other reason other than just his outlook and maybe his background that would lead you to vote against him. But that's the kind of candor I'm talking about, is that people would have to be much more direct about saying, this is the problem, and this is why I take that position. And one reason why I promote and try and argue for candor is because it's connected to something else that's important to me, and that's accountability. Ultimately, the process, I think, if it's going to work better or differently, depends on the extent to which people are actually held accountable. Accountable for what they do or accountable for what they don't do. A third difficulty here, now moving closer to the ground level, is what I call the problem of unilateral disarmament. This picks up on the image that David used to begin with. That's part of the problem with the Arab-Israeli conflict, is who wants to be the first to put the guns down and the weapons down. This is part of the difficulty in the Senate, is who's going to be the first? Which party or party's leaders are going to be the first to put those parliamentary mechanisms down and then sort of compromise, go along to get along? Which is going to be the first to do it? And, of course, the answer is neither, because each is afraid the other will then shoot it or take advantage of that party when it's its turn, when that wheel turns. So that's, again, part of the difficulty, is how do you solve that problem of unilateral disarmament? Who's going to be first, in a sense, to sort of take that risk? And then let's see if, in fact, there could be, and here's a fourth thing, some middle ground. Is there any room for compromise in this process? That's another issue or theme that we see throughout the years, is that there seems to be such little ground sometimes, such little middle ground. And you can ask yourselves whether you think there's any possible middle ground. What would a compromise position be like? Would you be prepared to simply accept, and here's the hypothetical, I don't mean to scare anybody here, a nominee like Elena Kagan to the Supreme Court? Or what other kind of nominees would you be prepared to accept? How do we understand merit? Is there some non-ideological way to define merit or judicial philosophy or judicial qualifications? Those are the kinds of things that sometimes tear the sides apart, complicate the agreements, and explain the divisiveness. Another difficulty, as we all know, and Simon alluded to this, it's the subject of my new book, I should say, is precedent. It's available nowhere, by the way. But it's the role of precedent in constitutional law. To what extent, to what extent does precedent matter? To what extent do people respect precedent? But here, the critical thing to understand, I believe, is what does it mean to say one respects precedent? Here, I might just respectfully disagree with Simon. Roberts and Alito have not yet cast a vote to override a single constitutional precedent. They have cast votes, in a sense, to weaken some precedents, but when they do that, they do it invariably to strengthen others. So is that a reflection of a lack of respect for precedent or a respect for other precedent? What exactly is that a reflection of? That's the complication with precedent, is that we know that a lot of people get invested in certain precedents, but what exactly... well, we got to get a little more precise and a little clearer on what we mean when we talk about respect for precedent. I don't think Roberts and Alito, at least from my judgment, are doing anything different than what I expected them to do. I think they're following pretty much the path I would have expected them to follow. I have not, maybe it's just, I'm not sure what that means about me, but I think in any event, I don't see them doing anything contrary to what they said or purported to be, or what we reasonably could have expected of them given their records. I will hasten through a few other possible causes here. One cause I think we can't underestimate is the point that was made by Senator Specter, and has been echoed here as well today. The president, we have to acknowledge, has been slow in making nominations. That can't have helped the process. That can't have helped his nominees. And we know that that was an issue and theme beginning with the second term. And that slowness, especially with the midterm elections coming up, can't have helped. That's a complication. So if you've got a slowness, or in fact a failure to make nominations by the president, that's a problem, of course, for the confirmation process. But here's another problem. It's the problem if the president doesn't listen to the senators. He has the constitutional authority not to listen. I certainly would defend that. But then it becomes a political problem if he fails to listen. And that may be the difficulty we see in part, is if President Bush is not going to listen to the senators, who are the ones that have to pay the price for the nominees he puts up. After all, they have to vote on them. They've got to fight for them or defend them or not. So one would think it might be some political justification for at least listening to them, finding some middle ground sometimes on nominations. But if the president doesn't listen, whose fault then is that? Last couple things we need to think about for the future. One is the rules of the Senate. Now here, I feel like it's deja vu, because when I was last had the honor of coming before the Federalist Society, and let me emphasize to you, I always consider this one of the greatest honors I can ever have, and I do appreciate it. I have enormous regard for this society and your intellectual integrity and your willingness to put up with me. The last time I was here, I was in the position of defending the constitutionality of the filibuster. And I took the position then, which is the position I take now, that the filibuster is constitutional for the same reasons that all these other procedures in the Senate are constitutional. So I would agree with Senator Specter that now that the Republicans find themselves in the minority, they are as entitled under the rules to do what they think they've got to do as the Democrats ever were when they were in the minority. The choice to take advantage of the rules is a political choice. That's not my business. My business is not giving political advice. But what I can say is that the Constitution allows the Republicans to take advantage of those rules to the fullest extent possible. And one can't claim a constitutional difficulty with that. So as we watch things unfold, keep in mind that, of course, now the wheel has turned, and Republicans can take advantage of the very same parliamentary mechanisms, should they choose, that Democrats had taken advantage of to obstruct their nominees. So this is part of the reason why, perhaps, this is the cost, if you will, of the Democrats' choice to take advantage of those parliamentary mechanisms. They made that choice. Now, in a sense, they've got to live with it and face perhaps the same mechanisms, in a sense, being used to frustrate some of their agenda. I'm sorry. The last thing I want to just raise is the fact that maybe the problem here is that we care too much. Maybe the difficulty is that when it comes to judicial confirmations and the whole process, we end up investing almost too much of our souls, too much of our interests, too much of our hearts and minds into this process, thinking that there's so much at stake. That's, of course, what may help explain some battles, that people think the stakes are so huge. But so what I come to as an ending point is perhaps picking up on one of the last points that Mr. Wallace made is, okay, do judges make that much difference? And what will be the harm in finding middle ground on judicial nominations? We need to be honest about that. If there is a harm, we need to be open about it. And then, of course, then we need to face the consequences of taking that position. Thank you.
First, does anybody on the panel have an urge to respond to something that somebody else said? No? Okay, I'm going to ask one or two questions, and then we're going to open it up for questions, any of you that can stay. This is a debate where both sides sort of say the other side is acting illegitimately. The Democrats seem to think that the Republican presidents are doing something wrong by picking people who are too conservative. They're not picking middle-of-the-road judges. And the Republicans tend to suggest the Democratic senators are doing something illegitimate by not confirming them. They're taking ideology into account. So I want to ask a question sort of to both sides of this. Maybe I'll pick on Ed. Do you think is it reasonable and fair for Democratic senators to say, I'm going to consider the ideological views of a judicial nominee, and I may oppose that nominee even if he or she is well qualified for the job. But nonetheless, if I think the person is too conservative, I'm going to oppose him or her. Is that a legitimate position to take, in your view, Ed?
Well, let me try to answer that briefly, but in a few ways. First of all, senators can vote up or down a nominee for whatever reason they want. I'm not sure that I would characterize any reason as illegitimate. Second, I think judicial ideology, properly understood, is perfectly fair grounds for voting on a nominee. My complaint with Democratic senators would be that they don't have a proper understanding of what judicial ideology is, but I don't criticize folks for acting on that basis. I would add, indeed, that I think it's Republican senators that you'll hear invoking principles of deference, and the reason for that is Republican senators are generally looking for a reason to roll over and play dead when a Democratic president is making the nomination, and that principle of deference provides that. What I want, above all, is an open, honest debate on the role of the Constitution, the role of law, the role of judging, I wouldn't say that any senator can't take anything into account. I do think when you watch the Judiciary Committee hearings, with few exceptions, on both sides there aren't many senators who demonstrate much of an ability to assess judicial ideology.
Does anybody else want to say anything on that? Yes, Simon?
Yeah. Does this work? Yeah. I would just say that, look, whether it's President Clinton, President Bush, President Nixon, President Eisenhower, when presidents nominate judges, they surely take into account the ideology of the nominee. Otherwise, we would have had President Bush appointing a liberal graduate of Harvard Law School for every conservative graduate of Harvard Law School that he named. That just doesn't happen. He's appointing or naming judges whose ideology he believes is consistent with his own. And sometimes he may be disappointed. Sometimes he may be thrilled with the result. Certainly, if the president uses ideology as a criterion, the American people have a right to know the ideology of the nominee, and the senators have a right to know the ideology of the nominee. Whether they discern it effectively through the hearing is a separate question. But there should be no limitation on, I think, on as full an understanding of a judicial nominee's ideology and judicial philosophy as a senator or as the public may want. And this is part of why, in addition to answering questions at hearings, nominees need to make available whatever writings they've done and speeches they've given, if that's what the Senate wants to explore.
David, if I may, Simon's answer takes things one big step further than I would go. I agree with Ruth Bader Ginsburg that the principle that ought to govern nominees' answers to senators' questions are no hints, no forecasts, no previews on issues that might come before the court. That, the question of how senators can get information and what information they get is distinct from the question of the bases on which senators may properly act.
Can I say one thing? Perfectly happy to have senators act on the basis of philosophy. I've always thought ideology is a philosophy you don't like. But at the Court of Appeals level, and even less so at the district court level, it doesn't matter all that much. Court of Appeals judges do not make a lot of philosophical law. They may interpret odd portions of federal statutes, but the big philosophical questions are settled over here on First Street. I mean, at the Court of Appeals, you've got drug cases, you've got immigration cases, you've got tons of stuff coming through your door. You don't sit around and plot to undermine the Constitution. You've got precedents, you apply them, and for the most part, that's your job. Maybe the D.C. Circuit's a little different. It's got a different sort of jurisdictional base. But for the most part, the Court of Appeals are a place where settled law gets applied to thousands of cases year after year after year.
Okay, so there's a general acceptance, I take it, that the other party, the party that's other than the president, can take ideology into account. Let me ask this one first to you, Simon. What's your view if a Democrat gets elected, takes office next January, a Supreme Court vacancy comes open, and he or she immediately chooses a very, like your example, a well-qualified Harvard liberal for the Supreme Court? And all the Republican senators said, well, you know, this person is obviously a liberal, maybe well qualified, but I'm going to oppose the his or her confirmation on that basis alone. Is that, I don't know, is that legitimate in your view, or is that overstepping the bounds of the proper role of the Senate?
Well, no, I think that each senator needs to make his or her own determination for a variety of reasons about how he or she will vote on a particular nominee, and that can include ideology. I think that let me give one example. I think that there are processes, and maybe this relates to part of what Professor Gerhardt was talking about. There are very simple things a president can do to make ideology perhaps a little bit less of a factor. And one of those is, for example, as far as I'm aware, President Clinton consulted with Orrin Hatch about every significant judicial nomination he made. I think that President Bush has obviously not done that. Doing that, and some of the steps that Mr. Wallace was talking about, meeting the nominees and understanding or hearing from them directly about their ideology and their approach to judging, can moderate that one's initial reaction to vote against someone because of ideology. So I think it may well be that many Republicans would oppose the appointment of a Supreme Court justice who they perceive as not likely to move the law in the direction they want it to go.
David, may I pipe in on that, please?
Sure.
I just want to make clear that I will oppose a judicial filibuster by Republicans in the event of a Democratic president. I'll do so not because of any view about the constitutionality of filibuster. I think Professor Gerhardt and I are on exactly the same page that the filibuster is as constitutional as the committee structure in the Senate. I will do so because of the value of accountability that he referred to. And you know, if the situation that David posited happens, I think it's incumbent upon Republicans to make a vigorous case on the merits against the nominee, if that's what's warranted, to vote and to lose. That's what we did, I'll say, when I was working for Senator Hatch during the first 2+ years of the Clinton administration. We had open battles. We spelled out in 60-page memos entered in the congressional record, memos that no one ever found any fault in. The defects say the records of Rosemary Barquette and Lee Sarakin. We did not dream of filibustering. We exposed what was going on. We lost those battles. I think we helped win some wars there. On the particular question of consultation with Senator Hatch, this is raised a lot, and since I was involved, I'd like to clarify a bit. The key thing to understand is that Senator Hatch and President Clinton had a common interest, mistaken or otherwise, in avoiding a fight. Senator Hatch never drew an ideological line. In fact, I remember almost jumping out of my chair when I heard him I was with him at NBC studio on a Saturday morning. He proposed Marion Wright Edelman as a perfectly acceptable Supreme Court nominee. What he was doing for President Clinton is he was helping him figure out which nominees would really create problems. Not on ideological basis, but really on personal basis. Bruce Babbitt, because there are lots of senators out west who just didn't like him and would have to oppose him. There is no one on the Democratic side, certainly not Senator Leahy, no one else on the Senate Judiciary Committee, who is ready to play that sort of role with President Bush. So the situations simply are not comparable.
It's quite interesting. Let's go to questions. Ron?
Well, I wanted to revisit, David, you drew up a contrast in the beginning. That is, I think it was about whether we should vote for or against the ideology. But I think the real question is one really Ed ended up with is, are we going to allow the senators to vote? You take Judge Southwick. People might say he's good. I guess most people said that. Some people might say he's bad. It's one thing to say the senators can debate that and vote, but not to let that vote come to the floor. It only came to the floor because of the fortuity of California with Senator Feinstein, I think it is,
right,
because she was allowed it to go to the floor. Once it went to the floor, a majority of the senators, including many Democrats, voted for Southwick. Now, Simon says that Southwick was wrong. Well, maybe he's right about that in some ultimate sense, but we have a democracy, and the world's greatest deliberative body, we're told, should deliberate but never vote. They should always deliberate before they vote, but to oppose voting, even after full deliberation, is something I think is wrong for either party to do. And to say now that the Republicans will be able to do it in a year if the Democrats win control of the White House seems to say that you did bad, we can do bad. What ultimately suffers is, I think, both the courts and this concept of democracy, where after you have all these checks, there is eventually a vote.
My sense is that over the years, the Republicans and Democrats have had different approaches to this. The Democrats and the liberals, when there's a controversial nominee, it seems to be, let's put this person up for public ridicule and beat him up a bit and embarrass him and deride him and finally vote him down. The Republicans used to have sort of what I'd call more like a disappearance strategy. Clinton would pick somebody and nothing. Months would go by, no hearings, no nothing. So actually, I don't know whether any of you had occasion to follow this. There actually was, I think, a legitimate complaint in the second half of the Clinton administration that Clinton's people would pick various people and they would get no hearing, no nothing. They would just disappear. Now, I suppose if I had to choose, I'd rather disappear than get pilloried in public. But nonetheless, both parties have sort of played a little bit of a different game with the appeals courts over the years.
Yeah, I mean, first there's the nomination, then there's the defamation.
Yes, that's right.
Take into account, though, that the Republicans controlled the Senate. The Republicans controlled the Senate in Clinton's second term.
True.
And now that the Democrats control the Senate, that is what's happening to Bush's nominees. They're just disappearing. They're not being attacked. The attack method is what you do when you're in the minority, and I don't think there's any precedent for the level of attack and the level of obstruction that occurred in Bush's first 6 years.
David, I agree with what Kurt just said, but I also think that what you said is an insight into what I see as a big difference, not one that cuts in their favor in any moral sense at all, but a difference between Republicans and Democrats. Republicans haven't been willing as much as they should to get out there and fight the battles openly. We did that during the first 2 years of the Clinton administration because we had no choice. But then they resorted to this obscure strategy of secret holds and not moving folks. Look, if we believe in our arguments, let's make them. Let's expose what's wrong with candidates. Let's go on the record and vote. But what happens is Republicans think that the safest path to re-election lies in these quiet little methods where they never have to actually take a vote. They're not accountable. No one back home is going to get upset with them. Democrats, by contrast, are driven by their mobilized base to be very, very aggressive. And I think what you see is a real difference in the incentives that the senators face at the party base level. And it will be interesting if and when we have a Democratic president, which I hope is until Mike Wallace's great-grandkid's lifetime, is how much the internet changes this. There's the obscurity that Republicans relied on, the fact that no one's really going to go through Ruth Bader Ginsburg's record to find the documents that I found and sat on. So no one, no one will know about that. Isn't going to be possible next time around.
Michael, did you?
Yeah, just a brief comment. I mean, this is both a separate problem, but it's also related to what we're talking about, and that is, of course, the nature of the United States Senate. I mean, partly what we're trying to wrestle with here is it's one thing to give the senators political advice. It's another thing to ask them to step outside their institution and ignore their traditions, rules, and the way that they operate. Partly what we're dealing with here, or partly what we're confronting, is whether or not nominations should be treated or may be treated the same as legislation, which, as we all know, sometimes disappears, which we know sometimes gets filibustered. And that's not the only thing that gets defeated in committees without hearings sometimes and other activities. So partly what we've got to do is, I mean, I understand the why there is a need to give political advice, but it's not as if the United States Senate is like any other institution. And so that's what happens. So we got to be mindful that once that advice sort of enters that atmosphere, it's a different place with different rules, and then you have to then think, okay, will the senators be prepared to ignore their rules, committee rules as well as the Senate rules, in doing business, whether it's on nominations or anything else? What we've seen, and this is what's so frustrating, I guess, for people, is they don't ignore those rules on nominations, and in fact, they think whatever the rules may be are as applicable to them as any other Senate business, and that's sort of what we're almost sort of confronting here. Is it the same? Is it different than other business? That's one question that needs to be answered.
I'd like to ask a question to Heller. You wondered, or you asserted that if there is, contrary to everyone's wishes, there is a Democratic president this fall, and he or she appoints a liberal Democrat nominee, you think that many Republicans will vote against that person on the basis of ideology. But the two pieces of evidence we have so far, as Ed Whelan mentioned earlier, is that in fact they won't, because I forget what the exact figures were, but there was overwhelming Republican support in the Senate for Ginsburg and Breyer, whose records were not a secret. And I'd just like to know on what basis you're saying that. And in fact, I think that really shows that in many instances, whether or not you think that was the right move to make as Republican senators, the Republicans were being intellectually honest, whereas many of the Democrats, frankly, who voted against Alito and Roberts, were not. And I think part of that has shown that the Democrats and other liberals who did support Roberts and Alito, who signed letters on their behalf, people who self-consciously identified as liberals and Democrats, some of whom had clerked for them, others who knew them professionally, said that these people were fantastic nominees. And I thought it was really interesting that the Democrats viewed their allegiance to their base as more important to them than the advice of people whom, in many cases, they knew through their professional circles. And in fact, I think in that vein, if, for example, Elena Kagan were nominated, I think there are many people who are conservatives and who are graduates of Harvard Law School, given her the atmosphere that she's brought to the law school, would in fact support her.
Well, a couple of things. I mean, I'm not sure that the Republicans who voted for Ruth Bader Ginsburg were doing so out of intellectual honesty. They may well have been doing so, and I'm just speculating, as I think you are, because they knew she would be confirmed, and why fight? Why? And this, I think, is similar to what Ed was saying, that in fact, it's a much harder vote in many ways for I think, for Democrats to have voted against Alito or against Roberts, which didn't stop the confirmation, but can be used to attack them. As you're pointing out, by having voted for Justice Ginsburg or Justice Breyer, what do you say politically? that's not a disadvantage if they were going to be confirmed anyway. And I think it is a disadvantage, actually, to Democrats who voted, or maybe a disadvantage to those who voted against Alito and Roberts, because then their opposition to those people is clear, even though they were confirmed. So I'm not sure intellectual honesty has anything to do with how those people voted, Republican or Democrat. It may have in some individual cases, and I would imagine that just as there were Democrats who voted to confirm Chief Justice Roberts and Alito, there will be some Republicans who would vote to confirm someone who is viewed as a liberal nominee.
It does seem, though, that vote has lowered the bar quite a bit for Republican senators to say, this person is qualified, but he or she's too liberal in my view. Because Sam Alito and John Roberts were certainly qualified, had a lot of experience on it, and were not seen as, I didn't think as extremists, but they could be. If I was a Democratic senator, I'd say, he seems pretty conservative. And so it does seem like it sort of lowered the bar for a lot of Republicans now to vote against Democratic nominees, should there ever be another Democratic.
That of course that's what makes it like a faculty meeting. The fact that it's got to be tit for tat, So, the question is, do we, should there be payback, for those negative votes? And at some point, you'd hope the people could be bigger than that.
And I'm saying there shouldn't be tit for tat. Again, I think Republicans should not filibuster any judicial nominees by a Democratic president.
But you do think they should stand up and vote against somebody who's really liberal, don't you?
Yes, and they'll end up losing. That's not. I mean, that's I think a responsible course of action. Make the case.
What if there's a Republican majority?
Well, if there's a Republican majority, which seems unlikely imminently, but if they win on that, great. I think I think that's the way the game ought to work with accountability.
Yes.
It doesn't seem that there's really any agreement as to what the system actually is. But that leads to the question, is there any agreement that the current system actually usually, if not invariably, produces well-qualified judges? And or B, does the system generally produce the best qualified people that we could get?
I've already said it's not rocket science. There are a lot of people who can do this job. I think the people who get through the system are perfectly qualified to do the job. I'm not sure who the best qualified people are. I wouldn't be terribly well qualified to be a district judge. I try cases, but don't do them every day of my life. I do argue cases up at the Court of Appeals all the time. I'm qualified to do that. But if you put me on the district bench, I'd get an evidence book and I'd learn how to do it. I mean, it's not that hard. So best qualified is more of the idea that there's an SAT for judges just isn't right. There's different it's a political position. It's part of how we govern ourselves. And in different places, you need different people for different reasons.
And maybe if I could just add to that, I mean, certainly historically, I think it would be not fair to sort of to evaluate the process in terms of whether it produces the best qualified, because of course the answer to that would be no. There have been some very well qualified people, but I am just guessing. You could probably go through most historical periods, find people that I think would be really terrific nominees, let's say Henry Friendly, who never made it to the Supreme Court. So, and I'd venture to say that a lot of those folks sitting on the court in the 19th century, around about the time of Dred Scott, were not the best qualified people in the United States. But this is just another way of saying the process is, and I've heard Justice Breyer say this, the process is ultimately political. And so we don't expect a political process to produce as an outcome the best qualified.
What Harry Blackmun said. Harry Blackmun said, becoming a federal judge is like being in the right spot when the bus comes along. I mean, it's just about that haphazard. But to go back to the Israeli-Palestinian question, these days there's usually a bomb on the bus.
Well, I agree with what Professor Gerhardt and Mr. Wallace have said. Just add a couple comments on this. One, I believe that the senatorial influence, which is really just a matter of Senate perks to patronage opportunities, that has grown way too large. This is another one of my bipartisan comments. Applies equally to both sides. When you see a real estate transactional lawyer in California by the name of Milan Smith getting nominated to the Ninth Circuit. Well, I have nothing against Milan Smith. Perhaps he's a perfectly fine attorney, but he's also the brother of Gordon Smith. That's not an accident. And there are plenty of other instances, especially with district court nominees, where it's going to be your fundraiser's wife or your, a cousin. I'm sure this has happened through history. This is politics. I'm not suggesting otherwise. The blue slip policy has expanded in recent decades. This notion that appellate seats in your state should be subject to your blue slip is something relatively new. I think that's bad. I'll also say, Mike said at the beginning that if you don't have a thick skin, so what? No sympathies. Well, Mike has very thick skin to go through what he's gone and to have the sense of humor that he still does. I think there are lots and lots of people who are not going to be ready to have their young kids see them portrayed on TV as villains. I was talking with a failed nominee the other day, talking about people going through his trash, looking for mail and stuff. There are people who just are not going to want to do this. So I think that the process has gotten very ugly, and I think it deters some otherwise more qualified people from putting their names forth as candidates.
Yeah, I just want to say that, first of all, having seen many, many judges myself write opinions, there's a range of, let's say, abilities in terms of writing. Just whether you're conservative or liberal, some people write better, they reason better than others. So part of the question is, what do we mean by qualification to be a judge? Do we mean a law degree from a well-known university and years of practice? Do we mean the ability to write and reason well? My own view is that qualification also includes something about one's approach to how the law is interpreted. And I think that's the view probably of the Federalist Society as well, that part of someone's qualifications one should take into account what that nominee's views are about how the law should evolve or not evolve, as the case may be. So I think part of the question depends on the answer to the question depends on how you define a person's qualifications. All the people who have been, for example, all of the people who have been confirmed are probably admitted to practice law somewhere. That's a pretty low bar. All of them have probably had a few years of some sort of practice or teaching. Yeah, those sorts of credential qualifications are probably present for every nominee, both confirmed and not. Although I will say that occasionally, of course, there have been nominees who have real problems in their records that are, whether of a professional ethics nature or otherwise, that probably disqualify them. But it really depends on what you mean by qualified to be a judge.
Any other questions around here? Yes.
I was curious on the advice and consent clause. I'm not suggesting this is a constitutional requirement at all, because it's clearly a somewhat vague term. But do you think the advice and consent clause implies that the Senate actually do a direct vote, an up and down vote? In other words, as opposed to, you talked about burying things legislative, which the Senate certainly has, as Professor Gerhardt correctly points out, has done all the time. Does the advice and consent clause apply anything different?
Now that I'm not running for judge, I can give you a constitutional opinion. No, I don't think it applies any such thing. It's, the Senate does advise and consent, but I don't think there's anything in the Constitution that says you've got this power and you must vote. I don't see how you get there.
Let me just make clear my question. I didn't mean it would be constitutionally enforceable.
Yep.
I meant, is it sort of, would it be reasonable to say, gee, advice and consent really means we need to act on the nomination even though we reject it, or does it not mean anything at all in that regard? Just advice and consent is, we thought about it and we thought the best thing to do was just let it lie there.
I think it's perfectly legitimate to say, Mr. President, our advice is you take this nominee and go away and don't bother us with him anymore. And that's, something. I will say this. It's nice to be able to talk about the Constitution again when you go before the Senate Judiciary Committee, at least when the Republicans are in charge, you have to fill out and answer a question about your judicial philosophy. And you make it as honest and as non-troublesome as you possibly can. And I mentioned something about Marbury versus Madison, and I swear they made me take it out. I mean, I don't know how you're going to talk about Roe v. Wade if you can't talk about Marbury.
Maybe just to follow up on that, I've been on record on that for some time. In the 1990s, when it wasn't popular for a Democrat to do this, I basically took the position that the advice and consent power actually did not require or compel any kind of floor vote. And I think it's because it's like every other power that Congress has got. It is a power that then that body's got, but the body also has the power to make delegations to committees, as you know. So whether it's a treaty or bill or anything else, the way the House and Senate are structured is they will then delegate that business to a committee. The committee's under no compulsion to bring it out. The failure to bring it out could well be just the decision that essentially that was our advice and consent. We decided to sit on it. That was what we concluded. One of the complications, of course, with the advice and consent power is that, how much time does it require? And you couldn't argue, at least based on the text, that it compels or requires a particular quick action. So then you could imagine, just inferring from that, they could take as much time as they wanted to give their advice and consent, literally years. So that may help at least explain constitutionally why things can die in committee. I'm just talking about why that would be consistent with the Constitution. Now, there's a whole other political problem with that. But at least I've long thought you can't argue from the structure or the text of the Constitution that the Senate's got some institutional obligation to have a final vote on every nominee.
Can I just add that it's really no different than I think, and I agree with Professor Gerhardt, that it's no different than any other constitutional provision that prescribes something Congress is supposed to do. One house passes a bill, it sends it to the other house. Does the other house have an obligation to vote on it? Well, you could try to cobble together an argument that, the other house sent it, the second house should vote on it, but that's just not true. And of course it's not true with legislation, and there's no reason, I think, even in constitutional structure, people who interpret the Constitution according to its structure, to ascribe any need for votes, up or down votes on judicial nominees.
Is there any other questions? Otherwise, we concur.
I came in late, so excuse me if this has been discussed, but how would you, Simon, and the rest of you feel about what the President proposed, it must have been 4 or 5 years ago now, which is basically a timetable. Not that it's constitutionally required, but you will hold a hearing within 6 months of getting the nomination. You will hold a vote within 9 months. If it goes to the floor, you've got another X months to do it. Now, forget the logistics of how you would enforce that, but just in principle, if we could come up with a bipartisan agreement and be confident that successive presidents and senates would stick to it, would you be in favor of something like that?
Well, the only way you could be confident that anyone would ever stick to it would be if it were a constitutional amendment.
Putting that aside, just in principle.
Well, I don't think that means anything in principle, because it would readily be jettisoned as soon as it became politically convenient to do so. But I will say that any sort of proposal like that, I think, would have to contain, that's all giving by the Senate. The Senate's giving to the President guarantees. It would have to be accompanied, I would think, at a minimum, by some guarantees from the President that he's really going to consult with the Senate members of both parties, so that the Senate isn't signing a contract without consideration. That there has to be, the Senate should not be promising the president act. They wouldn't do it on legislation. We're going to promise you a timetable on passing a bill you send us, word for word. We're going to either vote up or down on it within 6 months. Congress would never do that, unless perhaps there was an understanding that the president would work with senators or members of Congress to develop the legislation. Then there might be talk of a timetable.
The president made his own guarantees, not to the Senate, but to the country, that I will appoint someone to fill a vacancy within a year, things like that.
Well, those are worth about as much as President Bush's guarantees at the beginning of his term of office that he would encourage bipartisanship. So I don't know. I think if the Senate's going to agree to something of any kind, they have to have an agreement from the president. Why would the Senate unilaterally agree to timetables in any party?
I agree with
between Republicans and Democrats.
I agree with the heart of what Simon said. In particular, the very fact that the Senate has plenary power to establish its rules means it has plenary power to revise them. All this talk about President Bush, though, being polarizing and supposedly, not reaching out. Let's remember, among his first nominations were Roger Gregory to the Fourth Circuit, someone whom President Clinton had recess appointed to the Fourth Circuit. President Bush seems to have gotten no credit for that. There was also, I'm sorry, I forget the name of the judge right now, but there's a Second Circuit judge.
Barrington
Parker, thank you. Exact same thing. Now, frankly, I think the administration was a little naive. I think they should have said, we're going to nominate this person, you go ahead and confirm him, and we'll execute the commission, that is, actually do the act of appointment, only after you've confirmed folks for these spots. They didn't do so, but they got nothing out of this. And as I outlined at the beginning, I think the record of obstruction on the Senate side, the unprecedented record, overwhelms any possible criticism of President Bush as not being sufficiently accommodating.
Let me just add, though, just for the record, that I would and did give President Bush credit for the nomination of Roger Gregory, but of course he did it after the two senators from Virginia asked him to. So,
two Republican senators.
Right, exactly. No, two Republican senators. But the thing is,
George Allen got a lot of credit for that one too.
Yeah. So but I think it was to their credit they made the nomination. But in a sense, it brings us full circle back to whether, of course, there are two Republican senators he doesn't listen to, as we just found out today.
I think. Let me just say, can I say something?
Sure,
because I've been in the position. You don't solve political problems with schemes. You solve political problems with politics. Presidents get the things they want most, even out of Democratic Senates. The president really, and he's got to get credit for this among conservatives and Republicans, he really wanted solid conservatives on the Supreme Court, and he got them. When my nomination was going through the Judiciary Committee, he really wanted authorization from the Senate on military tribunals. He really wanted authorization of foreign intelligence. There was a war on, after all, and he got it. And if the president wants lower court nominees to be confirmed, then what he's got to do is want it that bad.
Well, thank you. Let me. I've learned three things today. This is not a Democratic fundraising luncheon. That Mike Wallace is a remarkably good-spirited person, and that we haven't resolved the disagreement over judges, and there'll be plenty of disputes in the future. So thank you very much for listening. It was a good luncheon.